And I also have the great privilege of being Clare's supervisor, along with Ilias Trisbiotis, likewise in the School of Law. And Clare's going to give us a talk today on the right to food and its implementation in the UK. Clare was originally a vet and veterinary surgeon both in the UK and the USA, where she worked at the University of Pennsylvania with specific focus on pathology. She then came to Leeds and did a law degree, followed by a master's degree, and she's now undertaking a PhD. The subject is the right to food, and the particular take on it, as in the title of this talk, is implementation in the UK. There's an awful lot of good work on the right to food that's been published in legal literature over the years, but it's tended to focus on developing countries. And Clare's pretty original focus is, as I say, a developed country, the UK. And I think she'd agree it's been a bit of a moving target over the last few years and remains so today. She's particularly looking at human rights and whether there's a right to food in international law, domestic law. And she also looks at the policy that goes around it, both in terms of the devolution, the different models in the different parts of the United Kingdom, and also in extraterritorial application, the international dimension. In addition, and not surprisingly, she's also got an interest in animal welfare law in view of her time as a vet, and hoping to publish on that as well soon. Now, mentioning publications, it's been a good news today, and I've just heard from Clare that she's had her first article published, which is in Legal Studies, which I think is generally agreed to be one of the top law journals. And to have it published while still a PhD student is very rare. So hearty congratulations to Clare on that. The other thing to mention is that she is naturally already a lecturer at the University of Sheffield. While she completes her PhD, she started in that post at the beginning of September, with mixed emotions, I must admit. Wish her well with that. I think the final things to mention is that this is another seminar within the series under the Global Food and Environment Institute, and other details can be found on the website and Eventbrite. And finally, before going further, just to mention etiquette, in that I'd be grateful if during the talk you could keep your cameras off and microphones switched off for the duration of the seminar. And afterwards, we will have a 10-minute or so session for chats function to prompt questions, and then I'll try and collate those questions, and we'll deal with those following the talk. And finally, I should note that the talk is being recorded and will be made available subsequently on YouTube. So without more ado, I introduce Clare, who will talk on the right to food and its implementation in the UK. Many thanks.
Thank you, Michael. I hope I'm not blushing too much. So those are contact details for me. And today I'm going to be discussing the obligations the UK government has in relation to the right to food, and briefly indicate some examples of why it's unlikely the UK is meeting all of those obligations. I'm then going to move on to discuss food policy in the UK post-Brexit and why it's particularly problematic in terms of the devolution approaches in the current legislative environment. And so it's more likely the UK government is not going to realise those obligations in relation to the right to food. I'm then going to explain what framework legislation is and why I think it would be a positive step to help enable the realisation of the right to food. So the right to food appears in a number of different international treaties that deal with various areas of law. So, for example, the Geneva Conventions contains requirements that there's provision of food for civilians and prisoners of war during times of war. The UN Convention on the Rights of the Child contain a right to adequate nutritious food as part of the right to the enjoyment of the highest attainable standard of health. However, the most expansive international provision regarding the right to food is contained in Article 11 of the International Covenant on Economic, Social and Cultural Rights. The UK has ratified this international human rights treaty, and so it has obligations to realise the rights, including the right to food, that are contained within that treaty. And just by looking at the right up on the slide, you can see that it's much more involved than just ensuring that everybody has sufficient food not to be hungry. But the complexity of these rights can cause problems, and these rights often require investment and more expansive policy development. And you can see why that would certainly be the case for the right to food as stated in Article 11. And this was acknowledged during drafting of the Covenant, and also the fact that different states had different socio-economic statuses and different infrastructure and different policy structures, and so that they couldn't all realise these rights immediately. And this gives us the idea of progressive realisation, and that states should be taking steps to the maximum of their available resources to realise the rights in the Covenant. But this doesn't mean states can do nothing or very little, claiming it's all their available resources, especially in the face of people going hungry in their jurisdiction. And this is because the rights in the Covenant are also stated to have a minimum core component, the fundamental part of that right. And this should be realised immediately, or in the case of countries that are struggling for economic reasons, they should be seeking assistance to help realise that minimum core immediately. And in the case of the right to food, this is the availability of food in a quantity and quality sufficient to satisfy the dietary needs of individuals, free from adverse substances and acceptable within a given culture. And the accessibility of this food should be in ways that are sustainable and do not interfere with the enjoyment of other human rights. And although Article 11 does suggest a very expansive right to food, the article itself does not indicate the specific steps government should be taking when trying to realise this right. And so one of the things my PhD does is create a framework in relation to the right to food, which has looked at UN documents, FAO documents, the Food and Agriculture Organization, and other soft law sources to clarify government obligations in relation to the right to food. So if we return back to Article 11 of the International Covenant, there are 6 key ideas or standards, as I refer to them, that are apparent. And these are areas where attention should be focused to determine what governments need to be doing in relation to them. And these are freedom from hunger, adequate food, nutrition, production, international cooperation, and equitable distribution. So if we now consider some of these standards in relation to how the UK is performing in the realisation of the right to food, I'm not going to say much more about equitable distribution and international cooperation, as they refer largely to foreign policy, trade policy that isn't the focus of this talk. And I also acknowledge that these standards overlap. For example, adequate food has to be nutritious, and the way we produce food can impact the nutrition of that food. But anyway, if we now turn to just quickly think about freedom from hunger and the minimum core of the right to food, this very fundamental part of the right to food, that ensuring nobody goes hungry, we have a huge and growing number of people in the UK, considering we are a developed and very wealthy nation, that are food insecure. And this, in developed countries, is usually due to insufficient income. It's a food poverty issue. People are hungry because they can't afford to buy food. And so this is a great concern and really does demonstrate the UK is not realising its obligations in relation to the right to food, but overlaps greatly with areas of poverty reduction. However, it isn't just about people's incomes. For the first time, certainly in my lifetime, during the COVID pandemic and also following Brexit, we have had periods where people haven't been able to access food, or food hasn't been available in, or some types of food haven't been available in supermarkets. And so legislation dealing with the right to food would also have to deal with situations such as this, and how to prevent those shortages of food, or ensuring people, you know, regardless of their income level, can still access food. But making sure people are not hungry is not the only part of the right to food. And so if we think about some of the other standards, for example, nutrition, We are struggling to tackle obesity and other dietary related illnesses in the UK. Various legislative suggestions, such as the high fat, sugar and salt legislation, keeps getting put back. So we do struggle to perhaps realise that component of the right to food, to make sure everybody has a healthy diet and we're reducing dietary related diseases. There are also some concerns that possibly the way the UK government is moving post-Brexit may not be the most sustainable ways to ensure production. Some controversial issues have reappeared, like the use of neonic pesticides, and also how much the UK government is going to allow the use of GMOs. And so these are also possible areas where the UK government may not be realising its obligations in relation to the right to food. But having said that, we clearly do have some law that governs food. I'm sure a lot of you that research various aspects of the food system and food will come across areas of law every day that is relevant to your areas of research. So why am I saying we need more law when apparently law isn't working at the moment? So just to give us some background, we do have protections for human rights in the UK. We have a Human Rights Act, and this provides specific protection for the rights contained in the European Convention of Human Rights, but these are not socio-economic rights. And for international law, so a treaty like the International Covenant, to apply in the UK, it has to be incorporated into UK law in the way that the Human Rights Act gives effect to the rights in the European Convention of Human Rights. And actually, in the article that was published today, I argue there is some very limited protection possibly available from the Human Rights Act and the European Convention. There isn't broad protection for the right to food. It would be very difficult to take the government or a government body to court saying you're violating my right to food in the UK. So this, raises the questions: how do we develop the right to food, and what's the role for the law when we don't have protection for the right to food in UK law? The other thing that I need to sort of explain is that food and agriculture policy is largely devolved in the UK. Wales and Scotland can make their own law in this area, as can Northern Ireland. I'm not going to say much more about Northern Ireland because of the current sort of political difficulties there and the sort of possible lack of a truly functioning government, so its food policy is probably not a priority. The other thing to say is that overall responsibility for ensuring the right to food is realised in the UK lies with the UK government. And the devolution agreement means that the UK Parliament makes law and policy for the entire UK in terms of trade in food and agricultural products, and more widely law for England. The Welsh Assembly and Scottish Parliament make laws for Wales and Scotland with regards to food and agriculture. And so this obviously has the potential for different countries in the UK to make law that diversifies on standards or prohibited or encouraged practices. And prior to Brexit, the degree to which this was happened was curtailed by an overarching framework provided by EU law dealing with food and agriculture. And so it limited the variation that could occur and the degree of divergence. And post-Brexit, we do have some law filling that gap: the Agricultural Act and the Internal Market Act. So the Agricultural Act is the main law that now deals with food and agricultural policy in the UK, but it doesn't contain any reference to the right to food or nutrition. It does require reporting on food security, but there's no standardised definition in the Act. And the first report in 2021 seemed to focus much more on imports of food and ensuring international supply chains. Of the 5 sections, only 1 discussed food security at household level, and there weren't extensive discussions of nutrition. And this seems to diverge somewhat from the widely recognised Food and Agricultural Association definition of food security, which is on your screen. So very briefly, the Internal Market Act aims to try and ensure a functioning of a UK internal market, the trade and sale of goods within the UK. This does allow some latitude for Scottish and Welsh governments to set their own standards for production. So, for example, Scotland may introduce requirements in relation to higher animal welfare standards, but if this resulted in England producing cheaper products, because they have a lower welfare standard, Scotland couldn't necessarily and probably wouldn't be able to block the sale of those goods. And so you might, especially, you know, if consumers in these times are very much being driven by cost, end up with the lowest standard across the UK being the default. And so we have this situation where we've already got the possibility for divergent and differing policies across the UK within the devolved countries. And we also have a situation where there is a massive spread of food policy across the UK government departments. So this diagram comes from a report from Kelly Parsons, who indicates around 60 ministries have some responsibility for aspects of food policy in England. So if we go back to the example of obesity, the Department for Health and Social Care deals with nutrition and childhood obesity plans, while the Department for Education deals with nutrition education and free school or on school meals, which would also be an important part of tackling obesity. And so we have this situation where we've got a large number of departments with no overall guiding framework, dedicated department or overall responsible minister with an overall oversight for food policy, and we risk gaps in competencies as well as overlapping competencies and incoherent policy. And the concern here is this all makes it less likely that the government's going to realise the right to food. But the devolved nations actually are taking a lead in this, and we've seen an attempt in Wales to introduce a food bill that had the primary goal of creating a Welsh Food Commission and providing affordable, healthy and economically and environmentally, socially sustainable food for the people of Wales. It also had a number of secondary goals, which you can see how they relate to the right to food as indicated in Article 11. Fortunately, this bill didn't progress and it was voted down in the Senate by 25 to 24 votes, and there was one abstention. In Scotland, they have made some good attempts. They enacted the Good Food Act in 2022. This legislation has a stated aim of creating links between food and policy at national and local levels. And it also indicates that departments creating this policy need to consider a range of factors, such as the environment, child poverty, education, and animal welfare. It also importantly recognises the right to food. Unfortunately, this doesn't incorporate the right to food within Scots law, but it does note that the Act should be working towards realising the right to food. And the government's also acknowledged that this alone is not going to be sufficient to deal with the rising use of food banks in Scotland. They recognise the importance of the cash first approach in this, and although they can't increase benefit levels because those are set at UK central level, they are providing financial aid to try and reduce food poverty in Scotland. And finally, they are trying to fully incorporate a range of human rights into Scotland's law, which would include socioeconomic rights such as the right to food. And so the Good Food Act in particular is of interest because it's an example of a framework law, framework legislation. And it's this that I'm suggesting would provide a good model for the rest of the UK to ensure more consistent, joined up food policy that would enable realisation of the right to food. So as mentioned already, the UK has ratified the International Covenant of Economic, Social and Cultural Rights. But there's no law incorporating the right to food and other rights in this covenant into UK law. And so this might be problematic in terms of making sure the government takes account of this right when developing policy, but it also is problematic because it means we can't enforce this right through the courts. And actually justicability of socioeconomic rights is particularly controversial in the UK courts. And there have been cases that have tried to use the European Convention of Human Rights to improve the standards of people living in poverty, and the courts are very reluctant to get involved unless there are very specific circumstances, because they see things like benefits and welfare policy as a matter for the politically elected government, and they don't want to get involved in areas that have big financial ramifications such as welfare policy. But framework legislation does offer a possible solution here. It would provide a framework to enable joined up policy, but it would allow policy to potentially be reviewed by the courts. And framework law has actually been suggested by the Committee for Economic, Social and Cultural Rights as a major instrument for the implementation of the right to food. And this occurs in General Comment 12. And although general comments of the Human Rights Committees are not law, they are a very authoritative source concerning interpretation of the content of the human rights contained in various UN treaties. And the committee indicates that framework law should include targets and goals, such as, and also benchmarks that can be verified and checked against. And framework laws suggested by the committee would also indicate how, in broad terms, these goals would be achieved, the institutional responsibility for them, the processes for monitoring, and the availability of resources, as well as the role of various members of the private sector, NGOs, and also international organisations. So if we return to the Good Food Scotland Act, the Act contains requirements that ministers must publish a national food plan setting out its main outcomes to be achieved, the way that the progress will be assessed, and the policies that will be pursued to achieve these outcomes. This is all in line with the approach suggested by the Committee of Economic, Social and Cultural Rights. The Good Food Act also requires scrutiny of the plans by Parliament and also consultation with a variety of organisations when developing the plan. And so again, this is in line with those suggestions by the Committee for Economic, Social and Cultural Rights. So in addition to the Good Food Act in Scotland, we also have UK-wide framework legislation that we can see as an example of this approach. And this is the Climate Change Act of 2008. Some of you are probably more familiar with this than me, but it requires the responsible minister to set targets and develop policy to achieve those targets in relation to the UK's net carbon account, in line with our obligations under the Paris Agreement. And the plan set by the responsible minister has actually recently been challenged in the UK courts. There was a case brought in part by Friends of the Earth, and this case wasn't successful on all grounds of the review where it was being challenged, but the court did find that the minister's plan was not sufficient to allow proper public and parliamentary scrutiny. And so, although it probably didn't have the full outcome that Friends of the Earth were hoping for, this case demonstrates the potential for framework legislation to enable courts to review policy in areas such as food and against the aims that the governments have set, and so make components of the right to food reviewable in the UK courts. So in conclusion, the UK arguably is making slow progress in realisation of the right to food and is likely violating at least the minimum core of that right, especially given the fact that the UK is a wealthy nation. And although the UK has ratified the International Covenant of Economic, Social and Cultural Rights, this right is not incorporated into UK law. Food policy in the UK is complex, and we have many government departments with some responsibility for aspects of food policy. In addition, food and agriculture are devolved competencies. Hunger is probably best addressed through measures relating to finance and increases people's income. However, for the parts of the right to food that are be progressively realised, UK-wide framework legislation would enable a joined-up policy framework with departmental responsibilities clearly outlined and the requirement of goal setting, with the potential for review by the courts of the plans to achieve these goals. This would help the UK progress in its realisation of the right to food, reduce food insecurity, and help ensure access to a sustainable food system for all in the UK. So I would like to thank Professor Michael Cardwell and Professor Ilis Trispiotis, my fantastic PhD supervisors, and I'd also really like to thank the Global Food and Environmental Institute. I've been involved with the Institute throughout my PhD, and it's provided me access to some really interesting topics to discuss and also some really interesting opportunities. And so thank you very much for inviting me to speak today. And I will stop sharing my screen and take any questions.
First of all, very many thanks to Claire. That was very interesting talk. I think the relevance was immediately clear. And also, as a lawyer, it kind of gives hope that the law does have a role in realising the right to food, and there's a purpose to what we do. So First of all, questions. We've got an initial question for Andrew Melville, is looking at when you're looking at use by dates, sell by dates, and perhaps examples where supermarkets are using that food for distribution when they can't sell it themselves. How does that affect adequate food? Is that nutritious and adequate?
I suspect that there's somebody on the call who knows more about sell-by dates and food waste. Well, I know there's somebody on the call who knows more about food sell-by dates and food waste. So please, Carrie, if I say anything that's incorrect, please correct me. I think it depends to some extent on what the is. If we're talking about canned food and packaged foods, obviously we're trying to get away, I think, from unnecessary use-by dates. Unnecessary sell-by dates. Use-by dates, obviously, of certain food products are absolute because of food safety, so that is an issue. And my understanding is that I think as certain fruit and vegetables age, they do lose some nutritional value. But if people don't have any access to any fruit and vegetables, they are going to provide more nutritional benefit than some. So, but it is an issue. There are debates which are sort of outside of this about, as much as organisations that share food do really good work, there are, potential issues about should people have to eat other people's leftovers or things that other people haven't wanted, which is one take on those. It's not necessarily the only take on those sorts of organisations. So it does relate to the adequacy of the food. If you're eating food that, while safe, isn't as nutritious because it's past its ideal use date, that could be problematic.
Thank you very much. There's actually two questions from Carrie Bradshaw. The first one is, while accepting the wisdom of having framework legislation, the question is how far is that likely to be enforced, particularly like you gave the example of judicial review under the Climate Change Act, and similar could happen under a food law. But at present, the government has been trying to peg back the scope of judicial reviews. So that's the first question: is judicial review going to have as much bite as one might normally have thought? And the second question, a bit broader, is what's meant by wealthy nation? For example, the United States is generally considered exceedingly wealthy, but can in all respects it be considered wealthy? So just two parts, the judicial review and justiciability and wealthy nations. Thank you.
I think I'll tackle wealthy nations first. I am talking about wealth in terms of GDP and those sorts of financial measurements. I think the UK for a long time was sort of listed as the 5th wealthiest nation in the world in those terms. We may have slipped down to 6th, but we're clearly up there in terms of those aspects. I appreciate that we have all sorts of issues with wealth disparity, for example, in the UK and in the US as well. So when I talk about the sort of wealth of the nation, I'm talking about the fact that we are a developed nation with, those sorts of economic measures of wealth. But I agree, we don't look like a wealthy nation in terms of other metrics, the sort of human flourishing and possibly human rights indicators. So that, I think, is a good point. Just to clarify, I'm talking about, very sort of economic measurements there in terms of wealth. I absolutely agree that I can't see the current government implementing a framework law like this. I don't think it's something that we could expect. I am slightly more optimistic that a change in government might be more likely to sort of think about doing something like this. I think that it's all about how the framework legislation is written and whether or not it gives the scope for the sort of judicial review that's needed. And so I mean, obviously that was one of the issues in the Friends of the Earth case, that the grounds and the way the grounds review and the way the act was written didn't require, if I remember this correctly, a quantitative approach. A qualitative was sufficient. And so you would have to carefully write the framework law. And I also think that that's also going to determine how confident the courts feel in their review. It grants the permission to sort of, I suppose they might see it as interfering, but it grants them the permission to review and pass comment on government policy in that area. But I absolutely agree. I think at the moment we're seeing a government that's trying to roll back from having, you know, standards and laws that it can be held accountable against. So I'm not that optimistic that this would be implemented by this government, but perhaps as something for future governments to think about.
Thank you very much. The next question is from Cindy Leung, and I think at risk of a bad pun is meat and veg, in that it's what is the role of supermarkets, which is actually one of the chapters in Clare's thesis. In particular, should they bear any sort of legal or non-legal responsibilities in relation to the right to food?
Yes, is the sort of simple answer. I think there are, I mean, the whole issue of what obligations, if any, businesses have in terms of human rights is a growing area of research. There is large consensus that they certainly have moral obligations not to hamper people's realizations of the right to food, or the right to health is obviously one of the other big ones because of pharmaceutical companies. So I think it's widely accepted that they certainly have moral obligations, moral responsibilities not to do that. Definitive legal obligations and responsibilities, certainly in the international arena, are not so well defined, and this is where it becomes problematic. But I think what is clear is that states do have responsibilities and obligations to stop businesses interfering with people's human rights. And so, yes, I think that certainly the supermarkets in this country have an obligation to do a lot more than they do. And I think that the UK has a legal obligation to make sure that's the case. So it's a sort of two-level thing. And I think in the future, we will better define, and there may well be treaties about the obligations of businesses in terms of human rights. But what we can say at the moment is that countries certainly have an obligation to make sure businesses within their jurisdiction, and probably in other jurisdictions that they operate, if they're based in that country, aren't interfering with people's human rights, including the right to food.
Many thanks again. The next question is from Susan. It's saying, could you use human rights law, a Human Rights Act or similar?
So the Human Rights Act incorporates the European Convention of Human Rights, and that deals with, so human rights, we have socioeconomic rights, which are things like the right to food, right to health, right to education, right to housing. And these rights that people often say are much more complicated to implement and so need much more time. And then artificially, because of the way the covenants were drafted, we also then refer to civil and political rights. And they are ones that the European Convention deals with, and they're things like the right not to be tortured, the right to life, right to free speech. And they are often said to require a lot less implementation. And unfortunately, in the UK, we don't have specific legal protections for socioeconomic rights. We only have the protections from the European Convention of Human Rights. And there are some ways that the European Convention can provide protection. And it has done. It's certainly, the European Convention has dealt with situations where prisoners, people in psychiatric hospitals, asylum seekers who are detained have not been provided with enough food. And they've seen that as a violation of Article 3 of the European Conventions that relates to torture and degrading treatment. But more widely, it's difficult to argue that, you know, currently everybody who is experiencing food poverty, although it's terrible and it's, you know, very much an affront to human dignity, we can't say that the European Convention would find that to be a violation of Article 3. And this is this is actually what I discuss in my article, and it's a very limited group of people that might meet the sort of thresholds for it to be a violation. And so outside of that, we don't have many possible sources of protection for the right to food in UK law at the moment.
Thank you. And I think there's time for just one more question, which is from Lopa Saxena, which is, what sort of mechanisms exist for communities or various community organisations who are in the front line tackling food poverty? What role can they play in influencing the progressive realisation of the right to food?
I think, they can form, an important part. I think part of the important part of human rights is actually discussing what communities themselves would want for their food environments. How do they want support? And I know different organisations, and this is sort of outside of my area of research at the moment, but I know there are lots of academics doing work with local organisations trying to develop systems to tackle food poverty in a way that best addresses the needs of that specific local community. And I think there is very much, different communities will have different, although there may be a commonality of that people aren't having enough to eat, the best way to address that will vary from community to community, depending on the age of that community, the location of shops. There are lots of different socioeconomic factors. And sometimes actually a local authority, local community response is important. But I think overall, there needs to be a framework at UK level that guides local authorities and how they support these organisations, and so areas aren't missed. And I think, that's the other important side of it, that very much in favour of local activity, and local NGOs really can support that. And I also think there's a role for NGOs in campaigning more widely. And obviously NGOs were very important in the development of the Good Food Act in Scotland, as well as that local activity. But I do think we need that overall framework to make sure that everybody in the UK has access to the food that they need.
Thank you very much indeed. A really interesting talk, and a very constructive answer to the questions as well. I think the sort of key take-home message, definitely take myself, is that law does have a role in this. Sometimes it's a bit sort of in the background, and the sense there's not much it can contribute practically. But I think you, particularly with this use of review mechanisms and framework laws, you found a positive way forward. And at risk of a spoiler alert, I should mention that Claire's hoping to write her next article on the role of supermarkets in this area. So watch out for that. I think it just remains to, first of all, thank Clare. As I say, most stimulating and informative talk. Many thanks. I also wanted to thank all at GFEI for making it possible, in particular, Penny and Sarah. And finally, by no means least, to the participants for their attention and for their questions, which have definitely stimulated debate. So many thanks to all, and look forward to seeing you for the next one. Thank you. Bye.
Thank you.